I pledge of allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let's pray. Father, we love you so much, and we thank you for all that you do for us. And God, we thank you for your Son, Jesus Christ. And God, I thank you that we live in a country where, God, we can have open forum and have open debate. And God, I just pray for tonight. God, I pray that, God, that just as you extended grace and mercy to us, God, that we would do the same to each other. And God, I pray that this time would be productive. And I pray that, God, that you would just help us to make decisions, God, that will honor you. In Jesus' name I pray. Amen. Amen.
All the members are present, so we have a quorum. As some of you may know, my family has had an unfortunate connection to the ongoing Title IX investigation. After reviewing all of the information we have been provided, including consequences of the potential outcomes of tonight's meeting, I believe the ethical, moral, and right thing to do for the community and the school district is to recuse myself from tonight's discussion and potential vote. I came to this decision based on the potential perceived conflict of the interest by my participation. I will now be turning over the meeting to Josh. Thank you.
Yeah.
Before we start, I've got a question for the board. We're tainted right now, we inherited a taint. I have known Miss Nellie since she was probably 15 or 16 years old. Played softball with her, her family. I've coached her for what, 15 years?
Probably.
Or longer. Her and my wife are very good friends. She's a teller at the bank I work at. If me being in on this vote would make anybody feel like I don't think this, I will gladly recuse myself from this vote because I don't want us to be tainted anymore.
I'm good with it. I think we're in a small community and unfortunately, we all have connections one way or another. And I don't know that any of us, we all come with some preconceived ideas and information. And I'm good if you're good.
I agree.
There's nothing in the statutes that would say you have to recuse yourself.
I just,
And so I
We're
think it's
working on
really a
being-
board, it's your personal decision, first of all, whether you think you ought to, and then I think asking the board was the appropriate thing.
well, we're working on transparency here and that's the main reason I brought that up.
I think it's a good thing.
Since we were asking questions, I'll ask a question. If we only have one board member still left on here from the previous board, and that board member issued a text that gave his opinion of the case and what should happen, is that a reason to recuse?
I would say no, and here's the reason why. There were no events after February when this district started its investigation last year. And so what we're talking about was the actual Title IX investigation, which is not subject to this lawsuit. That's not what this lawsuit's about. This lawsuit is about whether this district violated Title IX before the incidents happened to the plaintiff. And it's not a question, in this case, of events happening after it was brought to the attention of the board and they did their Title IX investigation. Now, the fact is, it's disputed about whether Coach Houston knew or not. He denies it. He says that he didn't know. If he did know, he would have brought it to the authorities and he would have investigated. But the mere fact that the Title IX investigation wasn't handled the way certain people wanted it to be handled is not what this federal lawsuit is about. Does that make sense?
Sorry.
I can try again if I need to. I just think that whatever the board's actions were, I know there were folks who were upset with the board and how they meted out punishment or how the investigation proceeded. But that's not what the federal law that plaintiff is trying to enforce is actually available to her. It's not going to be about how the board conducted its investigation, or, how the administration conducted its investigation, and how the board reacted to that actual investigation. If there's a violation of Title IX, it occurred before February of 2021. And obviously the text that you're referring to happened last fall. I don't know if that answers your question better, but hopefully it did. You want me to go ahead and address the board?
Can we do the consent agenda? We have.
Oh, I'm sorry, go ahead. I don't have the agenda in front of me.
Sorry. Here you go.
I don't need it, that's
Need a motion to approve the consent agenda.
I'll make the motion.
I'll second it.
We have a motion, so
First by Nate, and second by Connie.
all those in favor?
All those in favor? Motion approved. I will go ahead and let Mr. Earl speak.
Yes.
If you don't mind, I'm gonna stand up. That's what I'm used to doing. I appreciate the seriousness of this matter and the sincerity with which each of you will be approaching it. To be honest, it's a difficult decision because the reality is that this district does need closure. This district does need healing. And unfortunately, lawsuits aren't designed to do that very well, quite honestly. Lawsuits are a way that aggrieved persons can go in and seek what they view would be justice for them. And that's important in our system. When there's a settlement offer made to a public body, unfortunately, it's like watching sausage be made to have the board discuss that. There's nothing under the FOI that allows you to discuss this in closed session. Sunshine law would say this should be an open session, so it is. It hamstrings lawyers on behalf of public bodies because we can't be as candid as we'd like to be. We can't be as detailed as we might otherwise like to be because depending on what happens, the case may go forward. I've given you a memo, and it was my intent in that memo to give you some information in advance so you could digest it. The offer that was made, that was sent to us last week, was that Ms. Nellie would settle this case for $1, which is very magnanimous of her, and that her attorney would not seek any attorney's fees. Again, very magnanimous. The idea that the district would provide Title IX training had already been thought of by your administration. That has already been scheduled. It was scheduled before this proposal came to you. So that's happening in a couple of weeks, August 8th. The things that we then talked to plaintiff's counsel about are the next bullet points. We were concerned about the records that had been produced. Unfortunately, they've had more play in the public than they should have, quite honestly. It's your obligation as a board and this district's obligation to protect student records. That's FERPA. It's the Federal Education Right and Privacy Act. I may not have the acronym exactly right. But FERPA is what we talk about. And the federal law says if you disclose records of students, you risk losing your funding. Well, that would be a serious blow to the district. So your lawyers have tried very hard to prevent that from happening. And so we've worked hard on keeping the records confidential, and we asked the court for a protective order. This bullet point was agreed upon by counsel that, in fact, the records would either be returned so we could destroy them, or they would be permanently protected by a confidentiality order. And then the other thing that has to happen in a case where a minor is involved under Arkansas law, the court has to satisfy itself that the settlement is in the best interest of that minor. Not just enough to have guardian, next friend, parent to say, this is a good thing for my child. The court makes an independent finding. That will be a finding in front of our federal judge. I did not anticipate that would be a problem, but if the judge thought it was, then we might be back to square one. The last thing was, of course, the sticking point that I think we we've got to weigh heavily in this discussion, and your decision impacts your district. The plaintiffs' attorneys have asked that the district admit liability. Well, admit liability is a term that lawyers throw around. For lay people, what it means maybe is we're guilty. This is not a criminal context, this is a civil context that this case is brought, but that's what people think about. You do a mea culpa, it was my fault, kind of a thing. There's reasons not to do that, and I spelled those out for you. The cases that could be brought within the 3-year statute of limitations include those players on the 1920 basketball team, as well as the 2021 basketball team. 3-year statute means that the older players would have until this fall, perhaps, depending upon when something had happened to them, they would have 3 years from that time to bring an action. Is there another action waiting in the wings? I have no idea. I've had nobody make a claim or tell me that they're about to make a claim, but I don't have a crystal ball that's clear enough to tell you whether somebody will or won't. I think it's just important for you to recognize what that puts your district, the position that puts you in, should that happen. The only issue in that instance would be, well, actually 2 issues, would be the question of damages that person suffered. And those could be sizable, they could be small. But generally speaking, under these kinds of federal statutes, a successful party is entitled to ask for the court, and most often the court grants an award of attorney's fees. So I think it would be attorney's fees that you're probably facing the most exposure, at least in actual dollars. And then there's the second prospect of just future lawsuits unrelated to these incidents. It would be used against you in that setting. You don't want to be termed as a bad actor in litigation. I've already mentioned the fact that Title IX requires that you have knowledge of something. Before you can fix it, you have to know about it. Plaintiffs will contend and have a couple of witnesses that say they told Coach Houston. Coach Houston will say, no, he was not told. First time he was told anything was in February of 2021, and it didn't come directly to him from any of the players or any of the parents. It came through administration, and then he was told about it. That's what his testimony will be. But the district, when they found out in February of last year, launched an investigation. They did what the law requires of them in terms of that investigation. There's a whole, I mean, it's a brutally long set of regulations that entail a Title IX investigation. There's information that has to be shared along the way. There's an opportunity to provide counter information, and it goes on. There's appeals and so on. I can understand why people might be upset with how that unfolded, but that's not what this lawsuit's about, and it won't be about that. I think really that's all I need to tell you. If you wanted to make a counter proposal, this would be an opportunity for you to do that. And that's where it looks like sausage being made. It's hard to know what's appropriate because you can't do it in a give and take that might happen, let's say, at a settlement conference. But that's up to you. Obviously, my job is to simply tell you what the offer was and give you the consequences either way. If you decide not to accept this offer, the case will go forward. I've given you some milestones that will happen in the case in the next few months, and we'll keep you apprised if that's in fact what your decision is. Any questions that any of you have?
Yes,
Yes.
I have some. Okay, when you talked about that if there was another suit, which here we're into this almost, we're going on past 2 years, that most likely, anybody that wanted to would probably have come forward, I would think, at this point. And
I would like to think so, yes.
And with Miss Nellie settling for $1, it's not looking like a big windfall if you jump on the bandwagon.
Right, I understand.
So if there was another suit, you're saying most likely all they would get awarded were attorney fees, but then we would also have to pay
Your
our
attorney,
fees.
yeah, you would.
So,
Right. But you've also tied the hands of those attorneys. And I would say this, it narrows the issues. It ought to be a smaller lawsuit, but I'm not sure.
well, because you say it's likely to cause others to file suit, so I didn't know what you based that on, that
Well,
it most likely.
if I'm a plaintiff's lawyer and I see that a target defendant has admitted liability, it just makes it easier to get into court and see what you can get out of it. I don't have any basis to say that there's anybody waiting in line. I don't know of anybody, as I've already told you, that there have been no demands made by anybody else. I haven't talked to any other lawyers who told me, hey, I've got a client who's interested in pursuing this claim. What can you tell me, kind of thing. Sometimes I get asked those things. Sometimes I don't. Most often it's the latter. They're just gonna file it, but.
And this forever cast as a bad actor, since it would be a whole different board, whole different situation, is that really that big of a problem?
Well, it's something that gets presented to a jury if in fact it comes up that way. Yes, ma'am. It's not the end of the world. I'm not trying to paint it as such, but it is one more difficult thing that your defense lawyers would have to deal with in that context.
Okay, and then under your discussion of the case, it says the district is not liable for actions of students unless it knew about the instances and did nothing about them. So my question is that two separate issues? Because we haven't even, can debate whether we knew, we didn't know, we haven't been presented as this board any evidence that they did know. But we do know what happened and that nothing was done for a while, or what was it done to all the perpetrators? So are those two separate issues? Because
I
can see that we might not, but the other one, I'm looking at, we probably did do nothing to them for most of them.
Well, let me parse it out this way. I see those as together, and I see it together as for this reason. As I mentioned earlier, once you start an investigation, as this district did in February of 2021, that's a process. I'm here to tell you, no one has said there's any instances of anything happening after February of 2021. The basketball season ended, the investigation started, and that whole scenario, I think, has been rectified. Now, we can debate whether it was rectified soon enough, but not under Title IX. Title IX doesn't say there's liability because it took you an extra month to get somewhere in your investigation. Title IX doesn't say there's a violation if the board somehow didn't mete out punishment that maybe the folks in the community thought should have been meted out. To my knowledge, the investigation was thorough. There were actually two. The problem for the administration and for us as lawyers, for you, is that we can't talk about those things. We just can't talk about them because of FERPA. And that's frustrating to folks in the community, it's frustrating to the media. They want to know. Well, the student's right of privacy is paramount in this case. And it's paramount for the victims as well as the perpetrators. If somebody's wrongly accused of something, they don't need to have their names bandied about in the community. Similarly, victims don't want their name bandied about in the community at all. This whole situation was horrific. It's terrible. Should never have happened, but where the district function lies is once you hear about it, once you know there's something that's wrong, what have you done about it? And I'm here to tell you they did what they were supposed to do once they knew about it. Now, it's going to be contested whether Coach Houston's testimony carries the day with a jury versus what the other witnesses might say. But I'm here to say that's the defense we have, one of the defenses we have. And until the district for sure knew about it, and everybody agrees we for sure knew about it in February, that's when the district started their investigation. And what happened after that, as long as they did what they were supposed to do under the regulations, Title IX doesn't really apply in a federal court case. Did that help?
Yes, I'm
Thank you.
still, the part about what we did about it, I'm still not comfortable with that part.
Well, but I don't want you to feel like you've got to do a mea culpa just because you didn't like what the board did, you didn't like the way the investigation went, it took too long, or it didn't have the end result that perhaps some people thought it should. I'm here to tell you that there was punishment meted out, and you had two decision makers who made those decisions. The second investigation, that was not appealed by anybody. The decision maker's decision stood. I can say that.
Can you tell me how many victims the board heard from?
Well, according to the plaintiff's lawsuit, there were 17.
That the board actually,
Oh, the board heard from. There were only 3 appeals that I was present for. So I think that's all. And that wasn't, let me back up, those weren't the victims, those were the perpetrators. So I don't know, probably only 1 or 2 would be my off the top of the head answer in terms of who the board heard from. The investigation talked to all of them. Again, your function as a board is not to do investigations. Your function as a board, of course, is to stand by if somebody appeals something or if there's punishment to be meted out, that comes to the board, and then the board makes that decision. But that's why you have to kind of stay above the fray.
so mandated reporting has nothing to do with the Title IX?
That's right. It does not. That won't be heard at the trial, regardless of how it's played in the complaint.
Okay, so if we do not accept this and we go to, the district goes to the 8th Circuit and say we won, but then there's an appeal, then we have costs for that, right?
Yes. Yes.
Can you give some sort of estimate of what an appeal can run?
Well, let me just parse out your words a little more carefully.
Okay,
The U.S. District Court is in Fayetteville. That's who will hear the trial of the matter in front of a jury. Okay, the jury will decide these matters if it goes before them. There could be an appeal to the 8th Circuit from that level. And I think it's a little bit speculative to talk about how much that would cost. My guess is you're going to spend another $40,000 to $60,000 just getting to trial on this matter. The appeal probably, again, depends on what the issue is, how narrow or how broad it is. There's a lot of factors, but you're probably looking at another $20,000 or $30,000 if it goes to an appeal. And don't hold me to any of those numbers because I view my job sometimes as a fireman. I got to put out the fires that the other side sets, okay? And so I don't control all the things that have to be done to provide the defense that my clients are entitled to.
in this, it says if the case is not resolved at that conference that we're supposed to go to, before that, Ms. Nellie would like all the parties / decision makers to attend. Who would that include?
That's you.
So that, we're the party slash decision makers, no one else.
That's right.
Okay.
Well, let me be clear, Ms. Nellie would be entitled to attend.
Oh, well, I mean, from our side.
Yeah, from your side, it's you all. The board's gonna make the decisions, yes.
Okay. Then it says, if the case is not resolved at that conference, we will likely file a motion with the court called a summary judgment motion. What would be our chances for winning that?
I like them, quite honestly. I like them in this case,
But if we didn't win, we have to go before a jury.
yes.
How many, I know you can't give names or nothing, but how many kids were involved in this?
Total?
Yes,
Are you talking victims and perpetrators?
yes.
I'm gonna say a couple of dozen total. And I'm struggling because there's the 2 years involved. But yeah, I'll run with that. That's close.
So approximately 24.
There was a group that did it, and there was a group that it was done to.
Okay, so if we admit liability, then we would be admitting that we for sure knew ahead of time? Or could we come back with that we admit that we didn't report appropriately and that we didn't handle the investigation maybe as well as we should have because we started doing in-house investigation instead of having somebody, you know. But is that something we could maybe do a counteroffer?
What you don't realize, and probably hasn't reached the press, this was reported right away. And it was declined 6 times by the authorities to investigate. It was left to the school to do its investigation.
You mean the reporting was done right away?
The reporting was done right away.
Well, I have a newspaper here that I underlined that it says that Miss Kimball says she reported 3 days later and that it says when she spoke to you, then it says, when I spoke to our attorney Harwell, that was one of the things I asked. Do you think this should be reported? And he said, I think you have to know what you're dealing with first. Kimball said, his exact words were, I think you have to know what you're dealing with first.
And that's a correct quote.
So that
But-
wasn't right away.
Well, I'm saying to you that it was reported.
Okay.
And quite honestly, all of that's supposed to be confidential. None of that's supposed to be in the press. None of that's supposed to be found out by anybody. The system contemplates that those things will be anonymous so that we have people who will come forward. But since it's out there, I would just tell you it was declined 6 times. They didn't investigate.
Is that the CAC that didn't investigate?
That's right.
Did they ever give a reason why they didn't investigate?
Well, it's the same reason you've heard from everybody else. It wasn't considered a crime, and they didn't do it. They felt like it was something the school needed to address. But back to your question, Ms. Tenberg, is that how you pronounce your name?
Berg.
Berg? Okay.
Tenberg.
I'm sorry. That's why I say the admission of liability is troublesome because it's very broad. Your suggestion that we admit liability to certain things, I suppose could be a possibility. But again, if you accept my premise that Title IX is not about the reporting, it's not about whether we butchered an investigation, admitting those doesn't really address what I think the plaintiff is looking for. I'm not sure you're going to get anywhere with the plaintiff without an admission of liability anyway. So that's speculation on my part. I have had no conversations with plaintiff's counsel about that. But narrowing it down to say we're admitting liability about a certain aspect of the case, frankly, would help. But I'm not sure how we parse that out and make that happen. in this case, okay?
So like a counteroffer of accepting responsibility and not liability probably wouldn't flow.
Now we're, you know, having word games, we
Yeah, but
probably would.
There's a big difference in liability and responsibility.
Well, I understand that, but I also know very creative plaintiffs lawyers who love to play with words like that.
Understood, that's why I asked the
Yeah.
question.
Anybody else have anything?
I do, but it doesn't pertain to this.
Yeah.
I've got a lot of questions.
I thank you for all your questions.
We have been asked whether our decision to let some of the members of the audience speak. I don't wanna make that decision myself. I'm gonna
Do we have to make a motion?
I think the sense of the meeting is fine, you don't have to have a formal motion. If anybody's objecting to having public input, you can speak up. If you're not, then my encouragement was that you give some indication of the amount of time. I took more time than I intended to, but they were good questions, so thank you.
I have no problem with it as long as we stick with nobody bringing up any names like the law proceeds.
Yeah, let's do that.
Is there anybody that would like to speak?
I'm sorry. Good afternoon. My name is Jamie Harris. My son was the manager for the basketball team, the only male manager. For the 2019-2020 school year, the last week of school, we had a deposition and we testified at Mr. Harwell's office. And my son is the one that told Coach Houston. And we submitted the evidence that we had at the time to Mr. Harwell. And I just want to let you know that they did know after that date, and we gave them copies of the evidence and everything. And my thing is, I just want to make sure that the boys can actually have fun and enjoy sports. My son has left sports, band, everything. He doesn't participate in anything anymore. And I know bruises do heal, scars are for life, and they're dealing with scars.
Now, you're saying your son went to Houston.
November 9th, 2019, and it's documented, and he has the evidence of the communications we had between me and my son on it. Thank you.
Is that true? You have that documentation?
I don't have documentation, I have his testimony.
His testimony or what she said that you were?
I have testimony from both Ms. Harris and her son. That's all I'm gonna say about it,
Okay.
okay?
Could you repeat that date?
No, 11/9 of 19, he has pictures of a Facebook Messenger where me and my son were talking about it. And in our deposition, when we testified, we were there all day, last day of school. Ms. Kimball was present too. My son testified, and they did go into detail with what happened, what he saw, the evidence that we presented. They went through everything with him, and then they went through it with me too. So they do have all that in the deposition, sealed with pictures and everything of the evidence, backdated to November 9th, 2019. It started at 8:30 in the morning, and he called me after. It was a maroon and white game, and by 7:30 that night, stuff was going on, and he started telling me what was going on. He did have other instances after that, but that's where I can show you, pinpoint, date and time.
That was 3 days before it was,
No, 2019. They are saying they found out February of 2021, or I believe, but it's the year before.
And how long from that till when you told, you say you told Coach Houston?
It was within 2 weeks. In the school, I approached him. He has our full conversation in the deposition, and he told my son pulled him in there. He said, "I will handle it, don't worry about it, we will get this handled." Nothing happened. So then I called Mr. Houston, and he assured me something would be done. Nothing was done. I ended up sick, I had to have brain surgery, so I was gone for a little bit. I came back in December and I saw him at a practice. There was other people in the gym, not many, but he acted like I didn't even talk to him and was standing there, turned, walked off, and my son was there with me. And recounted everything that happened that day. And I did not approach him again. After that, my son left everything, and he doesn't even want to be in the school anymore because he feels that he's not listened to. So I appreciate y'all, though. I just wanted to give you some clarification because I know it wasn't all listed in the documents that were set forth on decision-making for this.
So my one and only question to you guys will be, will you, who know her whole life, the rest of you are representing the citizens, you're a whole new school board. Will you listen to us as citizens and want our children protected as we're telling you? Or will you listen to the lawyer who lied to you right up here? We all witnessed it. You had the paper right in front of you when it comes to protecting our children. The ball is in your court now as you start your whole board and your whole tendency to protect us and protect our children. That's what we want to know.
If I've just been accused of lying, I resent that.
What was your name, ma'am?
My name is Jennifer Denard Straggy. I've been here ever since the beginning, the very first meeting, when my daughter was at the news report with Micah right here, and on the news said she didn't even want her future children to go to this school. And my daughter Nevaeh was in middle school and starts high school this year, and I fear for her.
The only reason why I came forward initially and joined in with Miss Nellie, I have not met her yet. I'm been here since 2015, but I officially not met her. My son watched a board meeting with Mr. Thomas standing up and saying that parents and paper was nothing but misinformation. I'm not looking for any money, nothing. My son just wants the truth. There was another case that something that got handled and it went for a full stint. This one didn't. He just wants the kids to not be allowed in the locker room. Don't let them play the sports. And if they did something violent enough and need to be a sex offender, let them, put them on the registry, what have you. But don't let it affect their whole life. His thing is he can't even play sports. We all have memories of what we did when we were in high school. I hate that our kids know this as what Huntsville is. We're small. We should love our school and love our kids and our game and everything. And it's sad to see these boys sit here and suffer and think that nobody cares. I will always stand for every single one of them, even if they're not here and won't give a name. I will be here, no matter what, chemo and all. So, thank you.
Anybody else have anything else to say?
Yeah.
Nobody else has anything?
Just mineral.
And I understand if you don't want to say, could I ask Ms. Nellie a question?
Sure.
Sure. What made you decide to do the settlement?
I'm her attorney,
Okay,
and we're just not gonna take questions, so.
okay, that's fine.
She probably wants to answer the question, but I'm here, so.
Okay.
Is there an issue with us basically not making a decision tonight and waiting until the settlement conference on September 15th?
That's one response. I would say to you, I don't know what the plaintiff's attorney's reaction might be to that. It's very possible they might withdraw their offer. It's possible that they would let it stand until then. But if that's what the board wants to do, that's what you think in your judgment is the best thing to do, it's in your hands.
Got a question. If we refuse this offer, is it gonna affect any of the other cases that's involved in the district right now?
There are no other
With some of the other individuals,
I'm sorry,
with some of the individuals.
there are no other cases right now.
I don't think they're through you. I think they've got private attorneys.
Well, then that doesn't affect the district.
Well, if our decision makes them win their case, and they shouldn't, it does affect the district.
Our decision makes them lose their
I'm
case.
sorry, I've stepped on your words and I'm not sure I heard everything you said, but I don't know of any other cases pending.
Right, okay.
Okay, is that
Yeah,
answering
and
your
you
question?
answered the question I asked
Okay.
you, fine. I have no recourse on that.
Okay,
That's
thank
good.
Anybody have anything up here?
Well, I've been thinking about this ever since we got it the other day. As you can tell, I asked a lot of questions.
Absolutely.
And I have got to go with my gut and my heart. It may be a poor decision, but I've seen a lot of poor decisions made by this board for not very good reasons. And I'm going to make this decision hoping it's a right one for the right decision. And I say we accept this, I make a motion to accept the settlement.
I second that motion. All right, we have a motion to accept this settlement offer. All in favor?
Can I say something before I say yes or no to this? My biggest thing with this is I hate what happened, number one. It's terrible. And I feel for you. I mean, I'm a youth pastor, so I understand exactly when kids hurt, it hurts. And it's terrible. I understand 100%. My only concern with this is, you know, there are a select few people who made decisions that probably were not correct, but I think there were other people that handled the situation, you know, like they should have. Does that make sense? Is everybody getting what I'm saying? Like, I think there was board members that made decisions that, you know, I wouldn't have agreed with. I think there was probably administration that made decisions that I would not agree with. But I think there's other people in the situation that did the right thing. And what my biggest concern is, I don't want people on that side of it that did do the right thing to feel, you know, isolated or like, you know, well, we did the right thing and we're still getting blamed for it. You know what I mean? That's where I'm at on it. And it's, I mean, I'm mostly in favor of this. But that would be my only concern is that, you know, on the same token as the kiddos that this was done to and them not feeling like they're getting justice, which, I mean, I know some of that has gone on. I also feel like there's you know, different positions in the school district that, you know, they did do the right thing and I just don't want, you know, this to affect them as well, if that makes sense. I don't know if I made sense at all, but that being said, I think we all want to move forward, and I think that's what we as a board want to do. I mean, that's the whole reason any of us ran is to make a difference and move forward, right? And if this helps us to do that, I'm willing to accept it. So I will say yes.
We have a motion by Connie, a second by Mr. Gullidge. We're all in favor? So we got a unanimous decision to accept the settlement offer. Now we need a motion to adjourn.
I'll second.
Mr. Glenn makes a motion to adjourn. Steve Owen second. All in favor?
I will not be able to be at the next board meeting. They changed Zachary's appointments in St. Louis, and so we have to leave on that Monday to go. So unless,
We'll
We
be
could-
praying for y'all.
okay,
Absolutely.
thank you. Unless there was a time we could move, which we might, I don't know, are we needing to hire people? If we moved it to the first week in August,
I would not be able.
or you wouldn't be able to, because you have the same health, you have health problems in your family. Okay, all right.
As long as we still have quorum for the 8th. If you want to adjust the times, you can. I would rather not move.
Okay,
I don't know.
yeah, no, I just didn't want to know why I would not be able to be here right up front.
Yes, ma'am. So we still have a motion to adjourn.
We got a motion to adjourn
And a second.
in a second.
I'll-
All in favor? We're done.
It's been murder.
You're
I don't know, we'll call her first. I don't know where you're going.